If everyone can grab a seat, we'll go ahead and get started. There's a scheduling change, so I know when it comes to conferences, networking and talking is something that everybody enjoys. Our lunch presenter came down with the flu in his house. I'm sure that's going around. It is in Missouri. It seems like it's going around in Ohio as well. Unfortunately, Toby Rittner with CDFA won't be able to join us for lunch. So it's not going to be a working lunch. It's going to be a conversational lunch. We'll give you that time to actually talk. So you'll be able to do that here at lunchtime around noon. But as you all grab your seat, I do want to start this session on, no, yeah, sorry. Had to think about some logistical things. So we're now going to talk about delinquencies. It's a topic that as admins, we definitely talk about behind closed doors a lot. It's a concern, it's a process. We heard this morning and when we were talking yesterday, each state is different. How we collect is different. How delinquencies and foreclosures are different. But, truly a delinquency is a missed payment in some fashion or form, no matter where you're at. And that means some action has to be taken in partnership with the capital provider and the property owner or sponsor. So what we want to talk about today is as open a dialogue as people are willing to have about delinquencies. Not just the numbers and how they happen, but how does that process work? What are we seeing on the legal side? What are we seeing on the lender side, admin side? Can we get any insight as to how the system can work better? Are there things that admins should be doing? Are there things that we are doing well? No one's opposed to a pat on the back when we get one. But we have a great panel today with Kevin and Jason here to talk about their perspectives in their marketplaces, in their sectors and what they're seeing. And definitely do look for your engagement, your questions as we go forward. But with that, Kevin, if you want to go ahead and start off.
Thank you. I'm Kevin Boyer. I was a 25-year employee of Dana Corporation, and about 15 years of that was spent in structured finance on large assets, and the rest of the time was in global operations. I've been in PACE since 2010. I was part of the Port Authority's DOE grant and launch, like Chris was in Cincinnati. And I think we actually formed the first PACE district in Ohio. We issued the first PACE-backed bond in Ohio. And then in 2014, I was part of a startup of PACE Equity, and we've done $1 billion of PACE to date. And 2 years ago, we were acquired by a large firm, Aquarian Holdings in New York, which is a multi-billion-dollar insurance company, asset manager. And so I've seen a lot of PACE activity. The one thing I'll kick it off with is we've never lost money. We may have to wait to get paid. So I think somebody used the term patient debt, but we've never lost money. So I think that speaks to the strength of the security in the project, but we'll talk about more details.
Thank you. My name is Jason Tiemeyer. I'm a partner here at Brooker Grade Wyatt out of our Columbus office. My office is actually just here, so this has been very convenient for me. But I also, really appreciate everybody making the trip out and sharing our space. I like getting to show this place off a little bit. And, great opportunity to get this group together. Really appreciate the effort Chris Jones and Josh and all the others have put into bringing this to reality. And so, really excited to be a part of this. I've been with Brooker Grade Wyatt since 2016, full time. And so really, have seen the, rise of PACE in Ohio. Kevin mentioned that, the Ohio PACE story begins, really when all PACE stories began in 2008, 2009, 2010. But, the market didn't really take off until, 15, 16, 17. And so, it's been great to have an opportunity to really see the growth of PACE as well as the life cycle of some of these transactions. To begin with, you're just originating, you're closing, you're getting things set up, and then over the last several years, we've been able to see some, a lot of these deals tick over into the collections phase, and what that looks like and what that entails. And obviously, this panel is one of the things that comes out of that. You deal with delinquencies, you deal with late payments, you deal with a variety of situations that we'll be talking about throughout this panel, and definitely encourage folks, if you have questions, if you have thoughts, comments, please. We want this to be interactive. We know each of you have experienced delinquencies or late payments in your programs, I'm sure, or if you haven't, you will. It's just kind of a function of an operating market. And so, hopefully we're able to share some experiences, share some thoughts, share some best practices. I know a lot of this will be a bit state dependent. Collections processes, delinquent processes, what the remedies look like is a bit state dependent, but I think there are some things that can bridge gaps, or at least best practices, or ways we can think about in structuring transactions that may help alleviate some of these issues. um, you know I'm thinking, look at Chris, I'm thinking about some of the experiences we've had even early on with bad actors that you can't see coming. If you're committing federal crimes, pace gets caught up in that, but you still have to work through the process. And fortunately, the process has worked in Ohio, and I know it has in other states as well. So, really looking forward to having this discussion, and I think there'll be some good to come out of it.
All right. So our first question is kind of level setting, looking at what the the delinquency landscape looks like. So for all of you admins out there, can you raise your hand if you have a delinquency in your program area? All right. Now keep your hand up. Those of you who have more than 5 delinquencies, keep your hand up. All right. So Connecticut, Missouri have more than 5. All right. There we go. So it does exist, right? But we're all still here. We're still operating, and we're still closing more projects. So it's not the end of the world. It's just a process we have to, as Jason said, it's just a process we have to figure out how to handle as best as possible. And just one more thing on the level setting. Missouri, we do both a direct bill. We use a Marinat where we bill the sponsor directly. That's off their tax bill, so they get billed one on the tax bill and then us. And then we also have where the county puts PACE on the tax bill as well. So we deal with both of those processes, but we are involved in the reconciliation and repayment process. So we're able to track whenever anything is repaid or not repaid, we know, just because of the way that we have to communicate with the collector to put the assessment on the tax bill, as well as when it comes through from the county, they still remit it back to us where Amerinet reconciles, our contractor servicer reconciles it. So we're always involved in that process and know, which has allowed us to have a process to where, in Missouri, it's due December 31 each year. But then if they're late, penalties start, and we call them within 2 weeks. We send a certified letter the next month. We have a conversation with the mortgage holder and the property owner and the county collector if need be to verify whether or not they're paying everybody. It's just us that's losing out. And then that way, we can have a conversation with the PACE capital provider to let them know what the local landscape looks like. As an example, while we have more than 5 delinquencies, oddly enough, 2 are, or 4 of them are from the same owners. So it's a repeat problem that I just think it's an unfortunate situation that party is in that we're trying to work with. But in that example, that party doesn't return our phone calls, doesn't return the capital phone calls, and it actually don't even they only return the president of the bank's phone calls. So it has not been the easiest resolution, but we are working on it, and just kind of like the last call Chris was talking about, last session. Chris was talking about each bank's project presents an opportunity to find the right solution. We found that's the same thing for delinquencies. They're all different based off of the personalities of the parties. Yeah. So the question was whether or not they're on bill or off bill. Uh, I, as an attorney, I would advise to say yes or no. But I don't do that, right? So here's my thing. I have found PACE capital writers willing to waive penalties and interest when there's a delinquency to try and help get things moving. When it's on a tax bill, you can't do that. The capital collector won't do it at all. They don't care who you are, how big the project is. If everyone in the family died, it does not matter. It's on the bill. Whereas if you direct bill, we just send another bill and it's fine. So I like that process, but um, I will say, there's always that risk of when you do it the off bill that they could pay the tax and not you, and that may present a problem that you have to deal with differently. I personally think you're still able to address it. You still have the authorities, even though it's not on the tax bill, but it's people uneasy. Did
So we do about 56% on bill and about 44% direct. And I would agree with you. I think we've had success working things both ways. Processes are a little bit different. I agree. We probably have a little more flexibility when we direct bill. If you ask my asset manager, her answer is going to be different. She prefers it to be on the tax bill, but we've had success working both ways. I'd like to start off by discussing how to avoid delinquencies. So for us, it begins in the underwriting process. And so we do a background check on the sponsors and on the entity that owns the property on every deal. We look at the developer team and the general contractor team and the architect team's experience in the asset class. So if we're doing a hotel, we want to see experience in that asset class, or assisted living or multifamily. We like to see experience in the asset class. I think we also want to confirm that they have the capital to complete the project. We do a high percentage of new construction, so getting to project completion is very important to us. And so that confirming that capital is there to complete the project by closing is very important. Sponsor liquidity is important. We get construction completion guarantees on every deal. And then, making sure there's adequate debt service coverage and PACE loan to value. And we actually are generally in a coordinated capital stack closing with the senior lender. And then that rolls into a coordinated disbursement process with the senior lender on a pro rata basis. So we're typically joined at the hip with the senior lender from closing through construction disbursement. So all those things are very important. We generally prefer to have a senior lender in place, but like Naveen, we've also done deals where maybe a sponsor just prefers to not use a senior lender or has a high percentage of equity in a project. We have done some deals without a senior lender. And then the onboarding process is really important. So we make a point to have discussions that begin with lender consent, but also with understanding how the disbursement process is going to work. Make sure the senior lender understands, the customer understands, make sure the customer understands how the PACE payment's going to be made. And then we also are reaching out to the counties at the inception to make sure we know who the county people are. We make sure we understand the county process. Part of our underwriting process, we also, over the years, we do what we call municipal due diligence memo, and that's a multi-page document that outlines the PACE statute, the processes at the program level, and it goes all the way through penalties, enforcement, foreclosure. We've actually built that into our asset management system. But we still, I was involved in Missouri probably 10, 12 years ago, and we had a recent situation there, but we still use the program people to help us reconfirm exactly how the foreclosure process would work on the a tax lien, and make sure that there's nothing there that we didn't understand. And they were very helpful in that process. And then from there, once it gets on the tax bill or we're direct billing, we're managing to a statutory payment date. And then there's a secured payment date that's associated with a securitization that's typically 60 days to 90 days after that date, but we're managing the statutory payment date. So we have as a case management in our system that tax payment is due every year, every 6 months. So we have over 1,000 cases in our system that we're tracking. And if they miss a payment, we're on the phone to them within days. Sometimes it's maybe a county error. Sometimes maybe they forgot about it, which is why it's important to understand at the customer level who's going to be cutting the check, the accounts payable department, and make sure they understand how the pace is going to be paid and when it's going to be paid. So we aggressively manage that payment date. And a lot of times, if we're missed a payment, we'll work it out before it even hits the secured date. So as I've said, we always have gotten paid. I think we've seen delinquencies go from 0% to still a very low percentage. And I was telling somebody, in our securitization documents, we actually have what's called a delinquency ratio. If that delinquency trigger is 10%, then the cash is tracked in a special purpose vehicle and it starts amortizing the insurance company's securitization debt. So we're nowhere near that number, and we take great steps to stay away from that number. We also have a risk management system, so we assign every deal a low, medium, or high risk depending on what's happening. So, a low risk might be that there was a contractor lien filed. A medium risk might be a bigger contractor lien got filed, and a lot of them got filed. Excessive change orders would be a medium risk. Completion delays that are longer than 3 months would be a medium risk. High risk is things like payment default, general contractor stops, or they change general contractors. They file bankruptcy. They're in default with their senior lender. The other step that we take that's very effective is we communicate very openly with the senior lender. So the minute they miss a PACE payment, we contact the senior lender and let them know that they missed the payment and make sure they're aware and see if there's anything going on with the customer or the project that we're not aware of. And it typically will create a default in the senior lender's documents as well. So we try and be very open and transparent with the senior lender. And as a result of that, typically, if we get into trouble, the senior lender is going to make a protective advance on the property, depending on the severity of the problem.
So I think one of the questions that maybe helps set the stage a little bit gets to what Kevin was talking about how to not get to the point where you're having delinquencies is, what constitutes a delinquency? Kevin mentioned the difference between the statutory payment date and the securitization payment date. That's a pretty common way to think about it, even if you aren't using, some sort of, bond or securitization pool on the back end. Even if it's about financing, you're going to have a payment, like the date on which the payment is due, and you're going to have a date on which you should actually expect to receive the funds. So, for instance, if we use Ohio as an example, property tax bills typically come out twice a year. The first property tax bill typically comes out end of January. The second property tax bill typically comes out end of June, early July. With the way Ohio operates, there's 88 counties. There's 88 different statutory payment dates. The state statute itself provides basically that every bill should be coming out by the end of the prior situation where you've got 88 different payment dates from the statutory perspective. The property owners have the ability to pay their entire amount due for a given year with the first half tax bill, or they can make the decision to pay in two half installments, two equal installments. So you have a situation where you're looking at, okay, when can we expect to get funds? Understanding from the property perspective, they've got these two payment dates that they've got to hit. The property tax distribution process runs through the counties back out to the municipalities, and then eventually pays capital providers. That is kind of where you get into whether it's a securitization date or just the date when a lender can expect to receive funds is going to typically be say mid-April or May for the first half, September, October, hopefully we're not getting into November, but it sometimes happens on the second half. And so it's helpful, particularly if you have new lenders coming in, capital providers coming in, they're understanding that just because the property owner has a payment date in January, you can't expect to see funds until later on. And so that's something that the market has adopted to, and it's consistent with what we've seen in other property tax bill secured financings in Ohio. You think of things like tax increment financing or TIF, or new community authority financing that we have in Ohio, or other items that end up on the property tax bill. There's been a convention that's been adopted where you really don't expect to receive those funds until May 15th, November 15th, or June 1st to December 1st. If you're looking at, for instance, a bond payment date, building in that time frame for understanding, okay, just because the payment date is one thing, the receipt of funds date is going to be different. So what that could mean is you've got a situation where a property owner has made a payment by the payment date, and the capital provider then is saying, okay, that's fine. I've got this other date in mind that I know I need to receive funds in order to hit, for my purposes, for, whether it's receipt of funds expectation or, making a bond payment. And, one of the things to keep in mind, one of the quirks with the way Ohio sometimes works that cuts against that a little bit is a lot of the counties will say, if we don't receive the funds by the payment due date, even if they pay the day after, we're not going to distribute the funds until the following distribution date. So you've got a situation where all of a sudden they're saying, well, even though we have the funds, a day later, we're not going to distribute the funds for the first half distribution. We're going to wait for the second half distribution. So all of a sudden you're in a situation where you're 8 months, 9 months from the when the date was paid until that money is actually being processed. And so it's going to be dependent on states. It's going to be dependent on even programs, where they are in that state of what that's going to look like. But it's incredibly important to understand what all of those dates and what all of the timelines look like to know, okay, if you have a property owner who misses their payment date by one day, what are the carry-on effects of that? And maybe they're not going to be considered delinquent in the state law foreclosure context until a certain period. Under the documents, that might be considered a delinquency. It might be an event of default. There's other factors involved, but you have to keep in mind kind of what is, when you say delinquency, what exactly are you getting at? Is it just at what point is the payment date late? At what point is the securitization date missed? Where in the process are we considering it quote unquote delinquent? And I think that's going to be a bit different depending on who you are, because if you're the county in Ohio, there's a specific delinquent tax list in duplicate that's prepared by the county in the second half of the year, that if the property owner misses their payments throughout the year, then the property itself will be placed on this delinquent tax list in duplicate, and that's what eventually can lead to foreclosure actions. So just because you have a property who maybe missed their first half payment date, that doesn't automatically immediately allow for the county to foreclose on that property. There's going to be this lag time built into the statute where they've got till the second half to make up the payment. They don't make it in the second half, that's when they can end up on the delinquent tax list in duplicate. And at that point is when, from the county's perspective, it is statutorily delinquent and potentially subject to something like foreclosure action. So, again, this is going to be dependent on the state and the program requirements, things. But I think it's really helpful to be very clear about when we're talking about true delinquencies. We think about just late payments and what are the carry-on effects of that. to what is, a property truly, state law delinquent for purposes of some of the remedies that kick in that we utilize for PACE financing. You know, there's, we potentially have options from a capital provider perspective to allow them to get funds in the interim time to meet a securitization payment date or some other kind of internal expectation of payment date. But then we also have to keep in mind, okay, capital providers receive funds. The county still sees this amount due as outstanding. How are we managing that? Are there there's there a second payment that's going to the county that's going to flow back through to someone on the back end, or could be refunded on the back end? Are we somehow being able to remove those charges from the county or from the direct bill? In view that the payment to the capital provider has been satisfied. So that's some of the things I think that we'll be getting into a little bit here is some of the ways that we can manage, late payments and things like that. But like I said, I think it's helpful to keep in mind, particularly, who are you talking to when you're talking about a delinquency? Are you talking to the county, and what is their view of what a delinquency is? You're talking to the capital provider and what their view of a delinquency is. Because it's one thing to say, I don't know from your delinquency rates within your fund. I assume that's missed payments and looking at it from that perspective. And so you could be in a situation where somebody has missed a payment, but maybe not even hit the statutory delinquent, tax list and duplicate to that level. And so, all of this goes into, I think one of the things that, Kevin mentioned from the capital provider perspective, but also from an administrator perspective. I know all of you have great relationships with the, local governments within which you operate, but that is one of the elements that is really helpful to understand is who is, in control of the, whether it's an on-bill process or even if you're off bill and you're looking to exercise remedies on that, who's involved in that and what is their role, what is their statutory duty, what is the process, but what stage in their process do they consider it delinquent enough to be able to exercise the remedies that they control, because it's going to be different. And we even within the 88 counties in Ohio, some counties have a very regimented process for exercising their remedies for delinquent tax lists and duplicate. We have some counties where certain county officials feel that they have more latitude than others. And so we look to manage that from a documentation perspective, from a relationship perspective. And there's things we do to try and alleviate that variance. But it is still something that everybody, I think it's really, really important to be mindful of, particularly as you're setting up a program and if you're operating within kind of a defined area, what that looks like. And understanding that, if you're in Ohio spanning multiple counties, that process might look different between the various counties. So, I guess just from a legal perspective, I can say we have seen a rise in late payments. We have seen a rise in true delinquencies. Again, to Kevin's perspective, it's still, a relatively small percentage wise, but it is, it is a trend that we are keeping an eye on and we are actively involved in, as they arise. I think on the whole, it's more often that we just see the missed payment variety than true delinquent property taxes and potentially getting to foreclosure. But it is still something that we're mindful of. One other thing, and this just gets to real quick to something that Josh mentioned, it kind of is part of the off-bill, on-bill, fee discussion and things. One of the things we've seen in Ohio, and I don't know, I'd be interested how other counties handle it. The way that the property tax collection process is supposed to work in Ohio is that if you are late, there is an automatic penalty that gets imposed on the property tax bill for your next time you pay, and it's usually 10%. And there's a statutory mechanism for the use of that 10% penalty, where it's going to the property or to the county treasurers and the county prosecutors, and is split 5% increments. We've actually run into certain situations. There's a basically a 10-day grace period built into the statute that's supposed to allow, if the property owner pays late, but within the 10-day period, the penalties can be waived. The problem is the penalty can sometimes get waived, but the 10% going to the county prosecutor and county treasurer doesn't. And so that leads to a whole other issue where all of a sudden we're going, well, yeah, you're taking from the corpus of the special assessment what was supposed to be paid through an additional penalty, but is no longer being paid through an additional penalty. And so that has been something that, again, gets to the late payment date versus the delinquency date versus we've got this other kind of 10-day period in there that has caused issues in the past that we're even still continuing to work on, and I think could potentially require a legislative fix at some point. So I know not everybody operates in Ohio, so it's a bit of a niche problem, but I just wanted to mention it as an example of, a particular issue that has popped up, can pop up, and is helpful to be mindful of, and is good to be mindful of in your own jurisdiction.
I think it's a really good point. You want to?
I have a follow-up question. So, if they're 1 day late and it gets kicked to the next period, have you been successful in going to the county and getting them to actually turn over the funds early?
Not really. That is a very good question. So it's something we've looked to build into certain counties that may be open to it, utilizing a structure where they'll say the only way we can release these funds is if for some reason we can count them as excess payments versus payments towards the special assessment. And so I think there's been one situation, and I hesitate to throw this out as a workable example, but there has, I think, been a situation where we've been able to have when it was caught, when it truly was just a 1 day late payment, it was caught very early on. A situation where we basically had to have the community wave down the special assessment saying, we actually don't need this amount collected for this half. And then the county was able to consider the amount that was actually paid a day late, consider it as an excess payment that was then refunded to the capital provider, to satisfy the first half payment obligation. One, I don't think every county is willing to do that. The other thing is you kind of run into this weird situation where, let's say the county just refunds the property owner and then the property owner goes away. Well, you've already got this community who said, we don't need this. What happens to your lien for that half? So it's generally the guidance we've given is no, there's not a way to get it out of the county beforehand. You could potentially try and have the community also, request it, try and go through a warrant process, but that hasn't always been most successful. Sorry, we have a hand in the back.
Yes. So to repeat the question and reminder, we are zooming this so we can provide it to folks or to you later. But the question was, having experience with collectors, foreclosures, using the local government, is there anybody who's had to handle delinquency foreclosure through off bill? And yes, Missouri has both. And we had a foreclosure that was through our statewide program, which is off bill. We have a process in place, right? So our statute gives us the authority to collect in the same manner as a ad valorem tax, and there allows us to do that. And so what we do is there's like pretty much a different foreclosure process. Uh, we work, first up, we work with the property owner and the capital or the mortgage lender to see if there's any resolution there. And in this particular case, the mortgage lender was overextended and they were not willing to go any further. Ultimately, what happened is the property was put into receivership jointly by the mortgage lender and the capital provider, the big note holder. And through that process, so it's not like a tax sale. Went through judicial foreclosure receivership, found a buyer, and then that's how they got paid. With that, though, just like some foreclosures, you're not going to get everything you're owed. The PACE note holder did not get any penalties of interest. They ultimately got paid the amount of the PACE assessment. So yes, it was totally their discussion. Our process uh, is that and this is something I actually was going to suggest is I think the best practices, and this is what allowed Kevin and I to have a productive conversation fairly quickly when his property was at risk of delinquency, is for programs to have written down your process for delinquency all the way through foreclosure, what your board or local government's involvement is, what your involvement is, what the capital provider involvement is, the timeline, um, and that way you can share that. I'll say one of our projects that is in delinquency right now is the bonded project. So now I'm dealing with the agency, which uh, based on that information, they're starting to get more engaged. And that's was my question. Are you still that? But to is our we would like to send a petition to our and ask the board for on that property due to delinquency. And in Missouri, wait 120 days. And then with 120 days and 3, so 3 years. Every county full 3 years. But the board has the right after 120 days to take action. So honestly, I'm usually trying to pull back the capital providers from not doing it on day 121. But in reality, you have that window. So they petition it. And then our other process is they would at the same time petition the board to have us jointly apply the foreclosure and assign our litigation rights to the capital provider. Uh, as the entity with the money at risk, as the entity who was involved in the underwriting, we are still involved, or we let them take the litigation timing issue, right? How quickly and how aggressive they want to be. Our board's decision was yes, you can foreclose. Yes, we will be a party, but you will lead that, and that allows the capital provider to be in control of whatever situation occurs. So, I don't know if you want to add to either of those.
Well, yeah, I think part of the question too is it's a bit state dependent on when you're talking about off bill collection. Is it a entity that has the remedy right as well, or is it just the collection process? Because I think in some states, you have an off bill collection process, but if there's a delinquency or non-payment on the off bill process, it gets kicked over to the on bill process, basically. Where you've got a situation where you'll say, hey, they didn't pay this off bill. This needs to either get on the tax bill or be treated as if it was on the tax bill and go through the county-based or government-based on-bill delinquency process. So I do think part of that is a question of just jurisdictional, because I know some of the jurisdictions that we've operated in that have utilized an off-bill collection process, the remedy process is still operated through the local government, and so it would be the same as if they had missed their on-bill payment. Yeah, this it's going to be really facts and circumstances and jurisdiction dependent. Because, for instance, in Ohio, the only entity with the authority to take a tax foreclosure is the county treasurer and the county prosecutor. And so in Ohio, the municipality or township is the one that has the authority to levy the special assessments. The counties are the ones that handle the collection, distribution, and enforcement. But I know that differs by jurisdiction. Up into Kentucky, just having a sheriff show up at your door with a revolver. But
Yeah, it's very jurisdiction dependent. So in California, which is a bond state, the CDFA is going to actually, if they were going to pursue a judicial foreclosure, they would do it on behalf of the bondholders. In other states, if it's off bill, when it becomes delinquent, there's specific timing by that we can actually petition to have it put on the tax bill and have the county enforce it, or we're assigned the full enforcement rights and we can pursue a judicial foreclosure. And that varies widely across the country with different timings. And so kind of understanding that whole process, I think that's where the program administrators can play a key role, is kind of understanding the nuances in the various, like we have 88 counties in Ohio, and we've got multiple, like St. Louis is very different from the rest of the country. So understanding exactly how St. Louis would approach a foreclosure was important for us to understand. In that specific case, we had a project that was struggling to get to completion. And we had a payment due in December, and he contacted us and the senior lender in August to say, I'm not going to be able to make my first PACE payment. So we had like a heads up of over 4 months to get in front of that, and the lender was in forbearance with him. And that was actually a pretty successful resolution because he missed his December payment, and by January 31st, the senior lender had made a protective advance. And we've had other situations where the lender was in a foreclosure process, so we just make sure that the lender and the county understands the PACE claim that's going to need to be paid when the property is sold. And that's a situation where, we're waiting to get paid as opposed to taking specific PACE foreclosure actions. I haven't had to take really too many PACE tax lien foreclosure specific actions that I can remember. Most of it gets resolved, well ahead of time. But you could wait a year to get funds in some cases.
It makes a lot of people uncomfortable waiting 3 years in Missouri. And to your earlier question, I would love to be able to like handle the off-bill financing, and then when it gets messy, go hand it to the county and have them deal with it. But to your point, not a single county would let me do that in Missouri. So, Wendy, you had a question?
Hi, following up on your suggestion that you spell out the delinquency um, process in each state. Um, we've been asked to do that or suggest counsel for specific projects by the capital provider. We thought it was pretty clear in our statute. We actually spent a lot of time clarifying the statute in terms of the remedy for PACE. And so whose role do you think that should be? You talk about the nuances in terms of, each deal. We could spend a lot of time with counsel trying to write out the opinion. I feel like it's the capital provider um, who really should be in that position, and they have specific items they may be looking for. But, thinking about efficiencies and thinking about we're all trying to get to the same goal, is there a suggestion you can make to the program administrators on how we could try to make a template or some sort of document for our programs that would allow you as the lender to utilize that for your project, so we're not all just kind of redoing it every time?
Well, as a capital provider, we'd like to be able to enforce and foreclose as quickly as possible. And we want to have as much control over that or as we can. So I think, unfortunately, there are other states, New York and Missouri, where that whole foreclosure process could take 3 years to 5 years, in maybe in the case of New York. So if and I'm not that familiar with the Massachusetts statute, I must confess, but how quickly does it allow for foreclosure to happen?
So we made it clear that it would follow the same process afforded to a private party, a mortgagee. So
Yeah.
we specifically clarified language in our PACE statute to make that clear, but we've still been asked for additional opinion.
Right.
And I'm just wondering, around the lender community, is there something like you could share amongst yourself in terms of the different PACE programs that would take that burden off the PACE administrator to create this opinion that you need, or is it something specific, to your each project that?
So who
you
has
create?
responsibility for foreclosing Massachusetts, the county or the PACE administrator?
PACE, no, it would be the capital provider has the rights to
Okay,
foreclose.
yeah.
We, not the program administrator, and we specifically do not, the city and municipality do not
Right.
want that.
If that's the case, we would follow the process. I don't know that we would actually look to the program administrator to,
Well, I guess I'm just looking for, like, when we're looking to close a deal, right? Like, something needs to be spelled out that we've been asked by the lender to spell out our process. And we wouldn't opine on that as the program administrator. We'd have to engage counsel to feel comfortable.
right.
So we've kicked it back to the lender, and you're telling us, in this forum, it would be really helpful to spell out our delinquency process, the waterfall.
Well,
how payments would be made. And
yeah,
I
I could maybe give you a little bit of help in that. I mean, we have our counsel, our transaction counsel do, like I said, a municipal due diligence document. And I could share with you what goes into that content, but it starts with the state statute, and then it starts with the document requirements, and then it goes into the specific details on exactly how you enforce delinquency penalties, delinquent interest, foreclosure, and the timing that's associated with each step along the way.
I think that would be helpful for program administrators to be able to look at.
Okay.
Like around 6 years ago was the first time that we had to deal with this. And so we were kind of learning as we went with the county because they had very, very specific and to that one of 61 Michigan counties way of doing things. And it was a little bit, messy because we weren't really sure how to do it. So a few years later, we worked with a treasurer in a different county on a different foreclosure. And this particular treasurer was, super step oriented, and he worked with us to figure it out. And now when it comes up, we've used his guidance to try to make it uniform across all of the counties because no one's dealing with it almost at all. And then when they do, it's infrequent, and then they get anxious and they don't have a plan. So if we've got this, we've actually done this where we've got the, put it all together in one place. This is how it happens. And we're just sort of saying, this is how it happens in Michigan now because, we've kind of worked through all the details. And it's been helpful. And it usually doesn't go too far. So usually you can solve things early.
Wayne County is very different than the rest of Michigan too, right?
Wayne County is different, but, they're basically willing to take the guidance from this other county. Yeah.
That's where you guys have been very helpful to us up in Michigan, is
Thank you.
laying out the landscape.
That's actually a great point. One of the things that I know, one of our local, we call them energy special improvement districts in Ohio. One of the ones in one of the larger metropolitan areas has done the last 2 years had a kind of a presentation day or just a chance for all of the member communities to get together and talk. And at one of them, they had representatives from the county treasurer's office come through and discuss from the county treasurer's perspective there what the special assessment process looks like from their end for getting them onto the tax bill, and then also then from the foreclosure side, or at least the enforcement side, how they view it from their side. And so I think, my representation is typically as general counsel to the Energy Special Improvement Districts, working alongside, to the extent there's program administrators with those districts as well on, what, on all the deals. We aren't in Ohio anyways. We're not representing the capital providers or the property owners. And, I think with some capital providers, and Kevin has mentioned their municipal diligence memo, I think that is something that from a capital provider perspective, they need to be comfortable, and to the extent they need to be comfortable, it makes sense that they're doing what they need to do to get themselves comfortable. I also know that some capital providers, maybe, I don't want to say aren't sophisticated, but just they haven't gone to that level of detail and are sort of maybe a little more reliant on the administrators or the local officials and kind of what that process looks like. And I think from the standpoint of an administrator, it's helpful to at least have an independent understanding of what that looks like. Because even from the capital providers, they should be getting the same answer. They may not be. And so it's helpful from an administrator's perspective. And so some of that could just be, hey, we need to just set up a meeting with the local officials who are actually touching this, or as you said with Michigan, or it sounds like in Massachusetts, there's not necessarily a local official that's operating that, but maybe this is just an opportunity for a session with the local council just to kind of understand what that looks like. So that way, when a capital provider does come in and say, "What does this look like?" you can say, "Okay, here's what we've done." But to the extent you're going to need a document, or you're going to need something, especially if it's to opinion level certainty, that the capital provider knows who to talk to or who to be engaging to get that. Because not all capital providers, their transaction counsel is going to be an expert in the law of that particular jurisdiction. They know the securitization metrics, they know the transaction document items. So I think, but even if you don't have a document written up yourself, which I think can still be helpful just from a general knowledge standpoint, or as these deals do, have delinquencies that may arise. The ability to say, okay, we don't have control of this process, but we're able to understand what's going on. But then, to the extent that there is something that's going to be necessary for a given transaction, and to the extent the capital provider's not providing that themselves, the ability to make a recommendation of who they need to be talking to get what they need to get to feel comfortable in that transaction. Because I can understand from your perspective, you don't want to insert yourself unnecessarily, open yourself up to, hey, this is the processes we've been told, but we're throwing a curveball, and capital provider saying you didn't tell us about this or something like that. That's definitely a position I understand you don't want to be in. But to the extent you can say, okay, this is what we've talked through with the applicable official. Here's this individual that we can go to if we need next level certainty on something, or if we have specific questions that need to be answered. So, I know that's maybe not super helpful guidance, but I do think that it's helpful for program administrators to have a good understanding themselves, whether or not they have a kind of a document that writes it all out or not.
And I'd add, and no offense to our capital providers in here, but I've worked with capital providers for a decade, and I'm still amazed at the number of times they come back and ask the same question. So they're dealing with 38 states. So, and our programs change, and sometimes they're not up on it. I think it behooves us as administrators. As an example, what I just wrote up last year. I've been doing PACE for a decade, and I didn't write it up until last year. But it's because our other delinquencies were very short. They were mistakes, something like that. We started to see more, and I started getting more questions, and I wanted to make sure I better understood it. And I want to clarify for you, right? There's a process part, which is just understanding, taking the different statutes and the program and putting it in paper, going, this is how it works. These are the timelines and stuff like that. Not a legal opinion, but just so you can explain it when asked. You can put it in your program manual, and that way you can point to the program manual and say, hey, everything I'm going to tell you verbally is right there. Check that out, and then come ask me a question. Because you do run the risk, if it's a legal opinion, that has a different weight and a concern on your part and the party reading it. But also, if someone has to read a statute, they may read it differently than you. And I think you want to be in control of what that statute says, right? If you're able to communicate that we without even a legal opinion, this is our understanding, this is how we operate, then Kevin's less likely to go, dang it, that's not right. He's going to say, okay, that makes sense. I'm going to live in your field and your world, and I'll operate that way. But if we let each capital provider tell us what our statutes say, that's when our lives get really, really hectic, in my opinion.
That's really helpful, and I'm thinking I actually need like a layman's version. I need like the legal opinion. There's maybe 2 or 3 depending on who the audience is. Specifically, my municipalities need that description, and so I think this would be helpful on multiple fronts, and that's why I think I do.
Always start with the simple first, and then wait till they ask for the hard stuff.
Thank you.
Chris.
program admins. The program admins that were in the room yesterday, I think we all, individually are tracking the PACE delinquency, so we know if we have 1, 2, 3, 4, whatever. But the conversation we had yesterday as admins is how we can be most helpful to capital providers such as yourself on more specific data collection as it relates to this. And not that you necessarily have to answer it now or any other capital providers in the room, but how could we as program administrators, I guess is the question, be more helpful with some of the specifics? Because I would just say this, of maybe the 3 or 4 that I'm aware of in the whole marketplace and our administration, I haven't really drilled down to look at, okay, is this are they all under $1 million deals? Are they all new construction hotel deals? I honestly haven't even drilled down. I have an idea of what they probably are. But I think that as administrators yesterday we're talking, I think we're wanting to try to get to that to see what the actual trends are, not only nationally, but in an individual state as well.
Well, and the other trend I think that might be helpful to know, and just thinking through the ones that I'm aware of, how many actually start after somebody has made successful payments for a given period of time? It seems to me, and again, I don't have the data, and this might be a good data point, is how many of these are delinquencies within the first payment or the first 2 payments? Absolutely. You close, you're a year later after capitalized interest burns off, and all of a sudden you're in that delinquency, situation, as compared to, hey, they've made 4 successful payments, and now all of a sudden something's happened. My sense is that the majority, if not almost all of them, have been outside of a situation where you've got somebody who's a bad actor who's got caught up in some other situation. But I think almost the majority, I would think, are in that first period. And so I do, from a data point perspective, that's something else I'd be interested in knowing.
Yeah, I agree with that, and a lot of that we can handle with underwriting. I think Naveen pointed this out earlier. I think capitalized interest is one way, and IO payments. I mean, there's always a lot of tension on the developers. They don't want to pay too much cap I, right? And as an absolute rule, we want to make sure we've got enough room in a new construction project when that first PACE payment hits. Make sure there's sufficient time after construction completion. And let's face it, over the last couple of years, we've seen construction delays, a lot of cost overruns. Somebody mentioned the interest rate issues. We've seen construction projects get into a little trouble with supply chain issues, cost overruns, construction completion delays. And we were alleviating some of that problem by the structure of the deals and the ability to diligently require. I think that the other, so to your point, a lot of this starts early, and in our disbursement process, one of the things we manage is as we're getting closer to that first payment date, we're asking the customer, are they going to be able to make that first payment? So we're trying to get proactively ahead of it. Also, whether it's a direct bill or whether it's on the county tax bill, if it's the first PACE payment, we're sending out a very polite reminder notice well ahead of time that their first PACE payment is going to need to be made by this date and it needs to be made on time, which again can alleviate other problems associated with late payments and stuff like that.
We are at time for this session. So we're going to go ahead and move. Our agenda calls for us to be like switching right over with our lunch speaker not there. I'm going to give us like 3 to 5 minutes of transition. So if you want to stretch your legs, get a drink or something, you can do that. But please join me in thanking Kevin and Jason for their time today. Thank you all for your questions and engagement. Our next session, if I can have Kim, Ryan, Dan, and Aaron come on up. we'll be talking about local banking and they are engaged in CPACE.